protection of society. The next is deterrence to you and to others. Third is punishment for the wrongdoing. And fourth is rehabilitation. And in your circumstances that you present before this court, all are very important and all have, I think, a very significant response by the court to these objectives. And I'll speak to them each individually in some way or another. In addition to the arguments that I've heard today, the court has very carefully reviewed the pre-sentence materials, including those statements or letters that were submitted. My reaction to those letters is that those individuals that submitted those see you for what you are. I think you are a loved individual. Those that wrote letters recognized the struggles that you've had over the course of your life. And today the court heard two stood out to the court in my mind. First is that expression of forgiveness, which is significant. And two, the discussion of consequences associated with choices. The other statement is compelling. An individual who testified at trial, I found, frankly, for what it's worth, one of the more credible witnesses during the course of the trial, and the tenderness that was expressed during that trial and just the sad circumstances that that young lady found herself. Today, there is also, in my mind, an expression of forgiveness and a description of, as she described, a father figure to you. All of these things are very important to acknowledge and are redeeming in the court's evaluation of what an appropriate sentence would be. But it's not the only consideration that the court must undertake. As I go back to those objectives, protection of society is such an important factor, and in this case, the outcome, the consequence of choices could not be any more consequential or dramatic, where someone had lost a life. You used the language screwed up, and that began with the possessing of a firearm. There were elements of self-defense in this set of circumstances and facts that were presented to the jury. And this court relies upon the findings of the jury. It is appropriate for this court to consider all of those circumstances for sentencing. I don't want you to think at all that the court would ever overlook the findings of the jury, that this is in fact a second-degree murder offense, and this court will sentence you in that regard. One of the, I think, most difficult challenges that this court has in fashioning a sentence is how to reconcile this prior criminal history. And it, frankly, sets you apart from the many loss of life cases that this court has been called upon to render a sentence. So I'm balancing the facts and circumstances, the jury's finding, and what glares at the court in review is this accumulated over the course of young adulthood and into these latter years at your age at 32 of one offense after another. As I review those offenses, I want you to understand that this court does not view those prior offenses as victimless. It would be a much more challenging decision for the court had you appeared with offenses that involved violence or additional weapons charges as I know the parties have reviewed. Many of these offenses deal with either substances or property. Also, I know that you've had opportunities in the community with probation. You've had an opportunity for a retained jurisdiction, and you've had prison as well. And you testified to that at trial. The relationship with Mr. Neddo and how you became friends. I would call out the statement in the PSI on page 5 where you acknowledge that you never should have had a gun. That is an aggravating factor in this case, and one wonders, had you not, what the outcome would have been. Was there way out? Was there way an out, or an out of this set of circumstances that began to unfold perhaps days before this killing, hours before the killing, or even minutes before the killing, with all of the testimony that this court heard, in my own common experience, understanding all of the things that your counsel even argued in terms of mitigation and circumstances, I'm left with the conclusion, and I hope you agree, that there very much was a way out of this without taking a life. And you may struggle with my statements when I say that, and as we get closer to the event, maybe it becomes more challenging, but I am convinced that there were alternatives to you removing yourself as one who should not have possessed that firearm, did, and then ultimately pulled that trigger and took the life of another. And you live with that. I would highlight that I have understood from the very beginning proceedings in this matter that has been upon your conscience, and you expressed that today, and I accept that you wish this had not happened. So the deterrence is the difficulty. What is a sentence that I can deter you and others from committing again? Rehabilitation, in all of my interaction with you over the course of this case, I believe you're right for the kind of rehabilitation that is needed. Because of the statutory limitations that this court has, in large part of discretion, I need to focus on that because you will be, at some point, assuming you conduct yourself in an appropriate way while in custody, released. That's a Department of Corrections decision through parole, but given the state's recommendation, they expect that as well. And then lastly, punishment for the wrongdoing. I don't have a lot to say about that other than you will be given credit for the time that you've served in custody on these offenses. Beginning with the unlawful possession, I sentence you to the maximum of 5 years fixed, with the more dominant offense of second-degree murder. The court is going to impose an 11-year fixed with a indeterminate period of 25 years. That is a 36-year sentence. It exceeds what the state had asked for. I do that primarily because of your appearing before the court today with a very significant prior criminal history and the loss of life being so consequential. I think it's necessary to have the state in your life well into your latter years of life, and if at 36 or 7 with that sentence you're close to 80. And I think that's the appropriate indeterminate period. These will run concurrently. The court will impose a $5,000 compensatory fine and a $5,000 fine. The court accepts that there will likely be restitution related to counseling if necessary, but that would remain open. That figure of $2,800, is that conceded by the state or the defense, Mr. Browning?
Yes, Your Honor.
All right. Mr. Dewey pronounced or stated that exact figure. It was $2,800. I know there was some change.
28, 86, 40.
8640. To you, Mr. Hendricks, do you have any questions for the court or your counsel?
No, Your Honor.
Let me advise you that you have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 expires in 120 days, and Mr. Browning will explain to you whether any of these remedies or options of relief have any merit in these circumstances. Okay? Very good. Thank you all. You may be excused. Yes,